Hi everyone. I'm so sorry. Of course, like any great, thing, technology you get to deal with. So thank you so much for bearing with us here as we got started. But we're so excited for today's webinar. But first, I really just want to say welcome to this webinar today. It's hosted by Travefy Academy, and we also have a really amazing guest, Laurence, who's going to share so much legal knowledge with us today on top 3 legal mistakes that travel advisors make. And we are so excited from this. We know a lot of users are excited. We had a lot of registered attendees. So thank you so much for being here with us. But just to quickly introduce myself, though, I am Stephanie Grice, and I'm the Senior Client Champion and Education Coordinator at Travefy. And I can't wait to introduce our guest as well, Laurence here. And I'll introduce him in a minute. But before we get started, I also do want to give a quick plug on Travefy Academy and just kind of what to expect on today's webinar. So really what it is Travefy partners with experts across the travel industry to provide free educational webinars through Travefy Academy. So these webinars are not commercial in nature to promote any organizations, nor does Travefy ever accept compensation for partnerships. So really Travefy Academy exists to provide powerful educational experiences and really just fulfill our mission to help power the success of travel professionals. So today's webinar is for informational purposes, of course, and we also encourage you also to consult an attorney or a certified legal professional for any specific legal needs or issues you might have, like Laurence here. So really our hope for Travefy Academy is just to become a resource for travel advisors, from a wide range of perspective and different experience levels, similar to like what you'll find in today's webinar. So with all that stuff, let's get started here. So I do want to say with the webinar information, just to kind of let you know here what to do, is that there is a question box. So there's a question box available to you that you can use to add any questions that you have throughout this webinar. And then we are going to have time at the end to go over those questions. So you will have time, to go through those questions. This webinar is also being recorded. So if you need to hop off, or if you have a colleague who missed it or you want to pass it along, it is being recorded, and we will send an email out to everyone after this with the recording. So you will get to check that out again. And now, for the moment we've all been waiting for, I want to introduce our special guest, Laurence Gore, here today. But to tell you a little bit about him and why we're so excited for him to be here, is Laurence D. Gore became a member of the Florida Bar in 1978 and opened the doors of his first office as Laurence D. Gore, PA, in 1979. And Mr. Gore is currently with the international law firm of Laurence D. Gore and Associates, PA, with offices in Fort Lauderdale, Miami, Buenos Aires, and a representative office in London as well. But Mr. Gore graduated from the Southern Methodist University and received his JD from Nova Law School. He spent considerable time in advanced courses, having studied at SMU's branch campus in Madrid, Spain, and Nova University programs at Oxford University, and the Hague, said it right there, has been extensively involved in international law for many years, serving in many capacities with the Florida Bar International Law section, including as its chairman and representative to the International Bar Association and founder of the Travel Law Committee. So Laurence's primary practice includes contracts, negotiation, probate, real estate, corporate, and tourism law. So you can see with all of that why we are so excited for him to be here. So Laurence, thank you for being here. This is really exciting.
Well, thank you for having me. I appreciate that.
Yeah. And real quick too, before I hand it over to Laurence, what we're going to do here is we're going to let Laurence take over, and you can see the slides here on your screen, and he's going to share with us, all this knowledge on today's topics. But then we are going to open it up, like I mentioned, for questions at the end. So keep those flowing throughout the presentation. And I also want to mention that you saw the 3 topics that we wanted to talk about today, but Laurence is actually going to talk a little bit about Canadian law specifically after too, and which also has to do with US law too. So we know we have a lot of agents in Canada, and we wanted to cater to you. So there will be a bonus section at the end for that as well. So with that being said, Laurence, I will let you take over now.
All right, thank you. I'm one of about 2 dozen attorneys in North America specializing in travel and tourism law. The majority of us belong to what's called IFTA, or the International Forum of Travel and Tourism Advocates. There's also IFTA North America, and we meet worldwide as well as locally every year in Fort Lauderdale. We have IFTA North America. It provides a great resource for us all over the world if you have clients that are in trouble. No matter where, we usually have an attorney available for you. Now also, I'm a former owner of a travel agency and tour company, so I've been through a lot of the ropes that many of you are going through, and finally decided I better just practice law instead of also run the travel agency. But I was asked by our host, Travefy, to discuss the most important issues and mistakes that are brought up in many of the seminars that we have conducted worldwide. Mistake number one: legal liabilities with your business. As you can see, we developed what we call the legal tune-up for travel agents. What this is a series of form work that we use and are available to travel agents and travel agencies. Now, the forms can be included on your website as an attachment, or referenced also on the first or second page at the beginning of your website. A notation such as the use of this website implies that the user agrees to the terms and conditions associated with the website. And thereafter, you can also use it, should be noted, it can be used in any associated client documents. You wouldn't want to put it on your tickets, of course. So we'll talk about several of these forms later, but let me go through these right now. First of all, insurance refusal form. As most of you know, you should always make sure that your client is offered insurance, but you need a format where he checks off a box or declines, hopefully in writing. So we have an insurance refusal form that you should be using, or creating your own. A refund form. Many of you do not have it. We see that it should happen, and in accordance with many court cases, if they're not told when the money can be returned or if it can be returned, you can be held liable. So you need to use those specifications in the formats and tell them if it's 60 days out, 90 days out, or perhaps non-refundable at all. A trip policies form. Now, this generally is something that is used if you're acting as a tour conductor or you're putting together your own tour. You want to specify what's going to happen in that tour, what has to happen, who is performing what services, and what you're conducted or liable for. And we have a general terms and conditions notice. Basically, that incorporates many of these that we're talking about, and that should be on your website. Now, we'll also talk about what's incorporated in there as a waiver form, so you make sure that you're not liable for certain conditions that are outside of your control, especially those that may be associated with a third party, the airline, the cruise line, the hotel, etc. In many cases, you want a trip assumption of risk form. Now, this is if you're conducting especially a high adventure type of tour where they're partaking in, say, scuba diving, mountain climbing, something like that. Anything where it could be a danger to the individual if he does not know what he's doing. So he assumes the risk. A trip authorization form also, that's generally something we only use when you have minors that are included, that the guardian or the parent signs off if it's a trip for a minor. Also, a trip reservation details. You should consider this, again, if you're putting together some kind of a tour. Again, you want to spell out what it entails and who the suppliers are. And finally, what's become most important these days, and we'll talk about that in a moment, is an agreement of consent to use of personal information. Now, when I first started doing some of these lectures, 6, 7, 8 years ago, and I asked how many are offering services under a sole proprietorship, meaning just under your own name as an outside independent contractor, 70% of the people would say, oh, yeah, I'm doing that. They're not using an S or a C corporation or an LLC. Basically, the forms of the business organization are a sole proprietorship, a general partnership, a limited partnership, and then a C corporation or an S corp or an LLC. For those involved in travel, we really recommend an S corporation or an LLC. I'll tell you primarily. A sole proprietorship has only one owner, and that can expose you to extreme liability in the event you're sued, because all of your personal assets they can go after. And believe me, I've had situations with agents that have done that, or they've actually formed an agency, but they put the place that they're operating out of within that same corporation, which then opened the entire building to liability in the lawsuit. Now, partnerships exist. Those can be two owners, and that's generally or more. That's generally in the format of an LLC. And a partnership can also, a separate partnership agreement should be included in an LLC or a sub-S corporation if you have more than one owner. C corporation you will see, but that's generally the larger companies. You may be Coca-Cola, General Motors, anyone where you have an unrestricted possibility of owners or they're selling shares, etc. You don't often see that in a fairly minor travel sense. A large corporation in the travel industry, a cruise line, etc., will generally be a C corp. Now, an S corporation is also used frequently, but that can have no more than 35 owners, and I don't think most of you need to worry about that. But again, generally we'll see 1, 2, 3 owners in the S corporation, and they issue stock shares, whereas an LLC does not do that. Some of the items you want to consider in your form of doing business is the fact that if there's a death, or there's a disability, or a retirement, or a bankruptcy, and that can force the end of the business if you have not formatted this into form of an LLC or a sub-S corporation. And you can use a partnership, as I said, within the LLC or sub-S so that the partners actually take over in the event of a disability or death. It's become extremely important recently with the new tax laws in 2018, because the new standard deduction was increased to $24,000 for married individuals, but other personal deductions have been eliminated. So unless itemization is used, there is no allowance for charitable contributions, home mortgage interest payments, state and local tax payments. Therefore, the use of a 20% deduction for the qualified business income is allowed in addition to your standard deduction, and it becomes very important. So the use of an LLC or a sub-S corporation for a home-based agent is a very important factor in tax savings, because the top corporate tax rate is now reduced to 21% for individual owners of businesses. So what you're basically getting by using an LLC, or in some cases for your protection, several LLCs, is an additional 20% reduction on your overall taxes. And a sub-S or an LLC can also be, the losses can be deducted from your personal income tax return. Now let's talk about errors and omissions and general liability. Of course, errors and omissions should be mandatory, and it should be required by the host agency. Some of the host agencies will provide this, but they should be charging for it. A sample clause, as you can see here, is the contractor is to provide for their own errors and omissions insurance in the amount of, here we put $1 million, and must submit proof of said insurance upon signing of the agreement. Contractor may at its own option purchase liability insurance through the agency, and or may have the cost of said insurance deducted from the commissions. Mistake number 2, unsecured practice with client information. First of all, many of you may not know, but if you have European clients, and some may not realize you have European clients because you're now dealing on the internet and you're dealing in a global economy. So the fact is that wherever the client comes from, you can be sued. You can end up being sued in France. You can end up being sued anywhere in the United States, for instance. So what becomes very important also is what we call a jurisdiction clause in your contracts. The jurisdiction limits that to the county, the state, or the country where you're doing business. The cruise lines use this with regularity, and most of it, of course, is either the West Coast or the East Coast. And you should be using it as travel agents as well. Now, the European Union and U.S. Privacy Shield Treaty basically stated that information that is shared by any corporation of a client's without their permission and that may be damaging to them allows for a lawsuit. We have signed a EU-US Privacy Shield with the European Union, and therefore, if you're doing business with any potential client in any of these countries within the EU, you could be sued. So the protection of client privacy records, the GDPR is what it's called in Europe, and it's been applicable since May of 2018. Basically, this is a fairly open standard, but says the processing of personal data should be designed to serve mankind. The right to the protection of personal data is not an absolute right. It must be considered in relation to its function in society and be balanced against other fundamental rights in accordance with the principle of proportionality. The biggest changes are wider enforcement rights, and the scope of regulation is now wider. Now, this will be a new format for the US. Right now, there is no federal law governing data protection. So it's been a state-by-state case of whether or not you have released that client information illegally or whether you've just been irresponsible. There was a case where one travel agent left a small diskette at lunch with their client records. That was taken. They were held liable for a lawsuit of $20,000 just because it was taken, not because anybody did anything with it, but because they lost it. Now, under California's new law, which take effect next year, web users can demand that a business tell them what personal information it is collecting about them and whether it is selling or sharing it, and if so, to whom. Consumers can also demand that a company delete their information. This law allows people to sue companies whose negligence leads to breaches of their personal data. The rules apply to any profit business that collects customers' personal information, from Google and Facebook to retail stores. The burden of proof is on the company, and the company must obtain the people's informed and unambiguous consent for processing personal data. Data collectors must report breaches. So if you know there's been a breach of your system, your computer, a hack, you need to report it to your clients ASAP. At least that's the first step to say, it's been a hack, I don't want to hide it. I'm going to work with you to make sure that anything that can be done will be done to protect the use of that data. Now, penalties for violations are $24 million or can be 4% of the company's global revenue. So we expect to see this situation as a federal law potentially within a year to 5 years. We don't know yet, but there are some great pushes on this. The privacy standards. You can see a recent story in Privacy International broke in 2019, and TripAdvisor and Kayak were sharing personal information like flight details, cabin class, or whether they're traveling with children with Facebook. Now, while the story didn't involve camera footage, it highlights how travelers' privacy can be gathered and used for profit by travel companies without the traveler's knowledge. A major problem is that seemingly secure and reliable connections that you use are not secure, as you've probably been aware. Many businesses have begun to use what's called the virtual private network, or VPN technology, and it provides business travelers with a secure connection between the sender and the receiver. Businesses using VPN can secure your company and clients' data from any entity monitoring the network and waiting to intercept your information. We have a number of horror stories in that regard as well when we speak live. Now, the exposure liability due to third parties, you may not really even understand. For instance, Uber, where a French man actually sued Uber for breaking up his marriage after the glitch let the wife follow his every move. As far as cruise lines, you know, those little cards that they give you or wrist bracelets, etc., that keep track of your credit card information, perhaps where you are on the ship, your favorite drink, and also access to cabins, etc., and your tours, etc. Well, these have to be kept also in a secure location. But if there's a breach and the cruise lines don't necessarily identify where this is being kept or whether it's being sold, these people can come back to the travel agency saying, you did not make us aware of this. If you're in a situation such as the Frenchman was, and one of your clients is traveling with someone perhaps they shouldn't be, the divorce attorney's first thing is going to be obviously to try to obtain by subpoena that information from the cruise line. And it may well come back to the travel agent. And technology thefts and liability in the travel industry. Passport information is a major target. In the infamous Marriott breach, which many of you may recall, millions of passport numbers, including 5.25 million unencrypted numbers, were stolen in what was considered the largest data breach in history. Passport numbers are most often used to track information about people and their movements and subsequent blackmail. Now, the liabilities. Well, courts have differed in different states and jurisdictions on whether stolen data is enough to cause harm. In other words, just because it's stolen, can you be sued? A U.S. district judge in Washington, D.C. ruled that plaintiffs must prove, that's your clients being the plaintiff, must prove harm in a data theft case. But other courts in other jurisdictions have previously determined that a breach of sensitive information is enough to show harm and that you can be sued just because you were careless. Now, one of the forms that we have developed in preparation for this is called an agreement of consent to use personal information. Basically, what we're saying is that the customer agrees by the use of, let's say, ABC travel services for the booking of travel, that certain personal information may be conveyed to third parties, relevant and necessary to the transportation and accommodation of your travel. ABC Travel shall not be responsible for the further use of said information by third parties by the customer. Personal information included. The personal information is the private information of individuals such as birth dates, passport number, dates of travel, occupation, destination, preferences of accommodation and meals, occupations, health information, frequent flyer, and other membership, bank accounts and credit cards, and other payment methods or financial information necessary to secure travel. We also state that the personal information to other persons, you being the client, have the legal right to share the provision of personal information as described above with other persons with whom you may be traveling and with whom you agree to provide ABC Travel said information. You, the client, will not hold the travel agency liable for the distribution of this information to necessary third-party suppliers or to further sharing or use of this information by the third-party supplier. Now, to the extent required by law, our liability for failure of such foreign supplier to protect your personal information is specifically excluded. If you have any concern about the disclosure of the personal information to a foreign supplier, you should advise the travel agency well in advance of any travel reservation or arrangement being made. And how long do we keep your personal information? Your information is retained only so long as we need it to provide information, travel services, or other services to you, and for a reasonable length of time thereafter in order to meet any identified purpose or other legal or business purpose. And the limitations on accuracy. ABC Travel may update the personal information that we have on file for you. ABC Travel will not bear responsibility for any personal information that is inaccurate, and you agree to supply updated personal information to ABC Travel as necessary for booking procedures, and that ABC Travel takes reasonable steps to protect your personal information. However, the agency is not responsible for any improper use of your personal information that is beyond our reasonable control, and we are not liable for the failure of any foreign supplier to protect your personal information, and that's specifically included. This is a kind of format that you're going to have to deal with because this, as you see with California starting it, is becoming a huge liability for travel firms. Mistake number 3, having the correct legal documents or forms. First of all, what about electronic contracts? We've been asked a number of times, if it's signed electronically, is it valid? Well, most travel contracts are created online, and to protect the legitimacy of these contracts, the United States adopted the Electronic Signature in Global National Commerce Act. The act confirmed that electronic signatures have the same legal standing as physical pen and paper signatures. Contracts and records of transactions can't be denied simply because they are in electronic form. And the Act grandfathered in existing agreements that were delivered electronically prior to October 2000. Now, there are exceptions, but you don't really need to worry about these in the travel business, as they cover things like wills, trust, adoption, divorce decrees, and certain areas of the UCC, product recalls, and a number of other transactions. Before the e-sign could be enacted, states did have the opportunity to adopt the Uniform Electronic Transaction Act, and it required a state-by-state adoption. But those who have not adopted the act in full have enacted something very similar. A comparison here, as you can see, between the e-sign being a federal act and the state act is basically that the state acts take precedence over the federal act if there is a conflict. Tour and travel companies can limit their liability and manage their potential risk by using waivers and assumption of risk forms. So let's talk about this for a moment. A waiver, as you've probably seen these in use, a waiver and an assumption of risk can be used as part of a tour. Always attempt to either sell travel insurance or obtain a waiver. That's a waiver format. You should consider medical waivers that cover physical fitness for activities that may occur on a travel. So it can be anywhere from heart disease, asthma, excessive alcohol consumption. You don't want to be held liable for that. If you're conducting a tour or sponsoring a tour in which you know there is some kind of high adventure aspect of the tour, you certainly want to include a separate waiver and mention what activity that is conducted, and that the person agrees that the agency or the tour company is not responsible for any accident that should occur outside of the limitations of what you've already planned. Now, most of these are contained in what we call the terms and conditions, a consumer disclosure notice. It includes a release of liability, a waiver, an assumption of risk, and arbitration mediation agreement. Some of the most important aspects is basically to inform your client that you are acting as an agent for the supplier. You are not the supplier. You're not the airline. You're not the hotel. You're probably not supplying any meals and side tours. The travel agency, therefore, is not responsible for breaches of contract or failure to comply with any laws, such as the Americans with Disabilities Act, or any intentional or negligent action or omissions on the part of the suppliers, which result in loss, damage, delay, inconvenience, etc., etc. The travel agency also does not guarantee any of the supplier's rates, bookings, reservations, connections, scheduling, or handling of baggage or other personal effects. You do not want to be sued for that. And of course, the client then acknowledges that they've carefully read the above paragraphs and expressly agrees to forever release, discharge, and hold the agency and its agents, employees, etc., not responsible for any activities that it is not conducting. The term of the agreement has a complete release and express assumption of risk, and the client understands the provision and legal consequences. And of course, now this is something that includes also, as we said, the entire document also would include forms such as using a ADR or mediation, jurisdictional terms and limitations, and so forth. This is not something that we necessarily recommend be signed by your client as a standard procedure, but be attached to your website. And as I said, can be conditioned on the website as a asterisk on page 13, 14, whatever you may want to say, but at least the use of the website is conditioned upon these terms and conditions. If you can get it signed, if you're running a high adventure tour, it's also, of course, preferable to have it signed. But we also don't want to drive away the potential traveler. An assumption of risk form. Now, many of you have seen these, I'm sure, and you need to participate in using these, especially, now this is a general release, of course, that we include in the terms and conditions, but if you are running a high adventure travel, which is very popular these days. So when signing an assumption of risk form, the participant acknowledges that he understands the risk inherent associated with the activity. For instance, if he's never been scuba diving before, he's not going to understand the risk. If he's never climbed up a mountain, he may never appreciate the risk either. But it releases the operator from the responsibility. And if you're the operator on any of these tours, you certainly want an assumption of risk release. And in order to overcome an assumption of risk, often the courts will require gross negligence on the part of the defendant. So if it's a supplier of yours and he has a drunken river guide or something, that will overcome the assumption of risk form. The risk has to also be relevant to the occurrence in the ordinary scope of the activity. Therefore, if the client of yours is, let's say he's decided to go paragliding or whatever on the tour, and that's not part of your tour, then it's not relevant to the occurrence in the ordinary scope of the activity. So therefore, you're not worried about anything with the assumption of risk form not being accepted. He's taken that upon himself. Now, some of the other aspects we look at are risk cancellation and insurance. As part of the overall documentation, basically the client releases ABC Travel from any duty in checking and verifying any and all passport, visa, vaccination, or other entry requirements at each destination, and all safety, security conditions during the length of the proposed travel. And you specifically recommend that U.S. citizens traveling internationally, including travel to Canada, Mexico, or the Caribbean, do so with a valid U.S. passport. Now, you do not give out information in terms of medical, etc., or you don't give out information because you can go ahead and you inform them, as we do here, that they should look at either the CDC online, or they can also go to travel warnings that the government provides. If you start giving out medical information or something more than what is required as a travel agent, then the courts will take the assumption that you have now provided that kind of information and you can be held liable for it. So be very careful in not providing it. You tell them to go to their own doctor, you tell them to go online at the CDC, and you tell them to go online at the U.S. State Department to make any determinations as to the risk inherent in travel. You're not also responsible for any injuries, losses, or damages in connection with terrorist activities, social or labor unrest, mechanical or structural integrity of air, sea, ground transportation and accommodations, diseases, local laws, terrorist acts, climatic conditions, acts of God, delays, changes, or cancellation of travel due to weather conditions, hotel services, accidents in health related to being in transit. Again, most of all of this language comes because someone got sued, and therefore continues to add this kind of language that you'll see in here that you do not want to be held liable for. As you've been seeing in the news recently, the problems that have been happening in one of the islands, where especially the Dominican Republic, and you've had a number of people that have been dying associated particularly with a certain hotel. Now, in the standard of practice for the travel industry, you are liable to know what is normal for a travel agent, reading the travel journals, reading other information, and passing that on. You are not liable for knowing specifics. So if you had a client who is at this point, let's say, traveling to the Dominican Republic, please make them aware to go online. And if they were traveling to a particular hotel site that may have experienced these difficulties, then you certainly should make them aware of the situation. Another important aspect is if the traveler's responsibility to protect their purchasers, and again, as we say, travel insurance strongly recommended and appropriate. The traveler's retention of tickets, reservations, or bookings after issuance by the travel agency will constitute consent to the above and an agreement on his or her part to convey the contents to his travel companions or group members. That's part of the problem has often been in a group travel that the leader fails to pass on this type of information to the other members of the group. And if the other member of the group has an accident, they may try to sue the travel agency saying they were not made aware. So again, a waiver and assumption of risk. Now, as a bonus, we're going to talk briefly about some Canadian law. Now, what's most interesting in this aspect is that the terms we're going to talk about and the conditions, while not necessarily adamant that they have to be followed in many of the states. Florida does have some of the same restrictions, in California as well, but they're important just simply, of course, if you have Canadian clients, but they're important simply because they are good advice and they should be followed on that basis. Considerations for Canadians. Clarity with respect to calculating the independent contractor compensation. And that's a whole other field we will talk about at some point, hopefully, in the future, and that's the independent contractor agreements. They're mandatory, of course, in several states, such as Florida. What should it include? It's mandatory in Canada. What expenses are deducted? What documentation will be provided by an agency to the independent contractor? What amount is payable by the independent contractor if the agency does work for the independent contractor's clients? Clarity with respect to payment of independent contractor compensation. When will the amount owing be paid? What documentation will an agency provide to back up these calculations? And what conditions are attached to the payment? All of these can be very helpful in the United States as well. So they're mandatory in Canada, they're not mandatory in the US, but look at terms such as this, especially if you're involved in an independent contractor agreement. Again, on the following page, indemnification by the independent contractor. What types of claim will the independent contractor provide an indemnity? The breach of the agreement, by the clients, by credit card companies, and employment benefits should all be addressed in an independent contractor agreement, and it's mandatory in Canada. The length of the independent contractor indemnification. It needs to continue beyond the termination of the agreement. Continuing on, of course, compliance with provincial BC, Ontario, Quebec travel laws. This is mandatory. They cannot meet a client at home. Very interesting because, of course, that's not the situation in any of the states that I know of here. Not using residential details in marketing materials. Payment from clients must be made to the agency. Now that's mandatory in Florida and several of the other states, but it is a very, very good policy to follow. I've had situations with independent contractors that have taken checks themselves, have deposited to their own bank, and then have issued what they considered the amount appropriate to the travel agency, and then directly issued the amount appropriate to the travel supplier. They can't understand why this is very much of a no-no and should never be done. Payments placed in the trust account within 48 hours of receipt. Again, mandatory in Canada, not in most states here. Client funds held in trust until all suppliers paid. That is a very good practice, obviously. Agency details, including license number, included in all representations. That's very good practice here, and in fact is mandatory in the state of Florida and several other states that you include your license number if you need to be licensed in that state in any representation on your website, on your documentation, especially in your advertisement. And you advise clients that travel insurance is available, of course. Full disclosure with respect to travel services that are provided to the client. Again, a very helpful idea for U.S. agents and mandatory in Canada. And advising clients of changes that affect travel services. And in Canada, they have to, believe it or not, they have to pass applicable professional exams in the travel industry. Now, our associates in Canada, just to briefly mention about them, Doug Crozier and Tim Law. They've been from a firm in Canada for a long time practicing the travel industry, and we associate with them quite frequently when we may have a mutual problem between the U.S. and Canada, and they're good members of IFTA. Contact details for ourselves, as you can see right here, and now I will pass it back to our host in terms of any questions.
Yeah, thank you so much. That was so much. We got tons of questions to go through. Real quick, apologies. I thought I had my camera off, by the way. I heard a couple people say I like to sway my hips and I was moving. Sorry to make you dizzy. I turned it off though, so hopefully that helped. So just want to say apologies for that. Didn't purposely mean to do that. But so all these questions though, so I tried to break them down because we had all kinds of questions and all the different types of mistakes we were talking about. But one of the biggest questions that we got really quick that I want you to chat about, Laurence, is about the forms. Where can people get these forms? A lot of agents were asking, are these available? Where are they available? Where can they find these, a lot of the forms that you were going over?
Well, what we were doing when I was doing several of the lectures before, the same kind of questions came up. So we developed basically a pen drive, and which contained all the forms and also a couple of our seminars, which were usually 1-hour seminars, and we made those available from our law office for a price. That was $199, but we also can supply online all of the forms for similarly reduced price of about $99. So you can contact our our law firm for those forms, and we'll be glad to provide those.
Perfect. Awesome. And a question here that just came in too is, do you or your firm offer advisor packages for those forms?
Yes, we do. We also have an increased situation where we will offer a substantial discount to travel agents, where they not only receive the form, but we can personalize the format to their agency, include their agency name, letterhead, and we do send out a questionnaire to the agency or the agent, which helps us personalize the form. Beyond that, yes, we do have another package that we offer where we can get continuing advice throughout the year, fill out all the form work, and specifically assist the agents for an entire year for a flat fee, rather than every single time you pick up the phone, you're going to get charged.
Perfect. Yeah. And someone just mentioned too, the website that's on here right now. It might, yeah, it looks like it has a little bit of a spelling error. I think that's my fault. It's your website though to get this information is goreinternationallaw.com. Is that correct?
That's our general website for the law firm, yes. But
Perfect.
you can contact us through, as I up above, through the email. We also have, we should have that on there, but an additional email, which is which is Gore International Law at gmail.com.
Perfect. Yeah. And anyone on here too, after you get the email follow up after this, feel free to reply back to us and we can get this contact information to you and that website as well. So feel free to reach out about that. But now I kind of want to talk about, so the first mistake, so I kind of trying to keep these all into one here because a lot of the same kind of questions were a little bit answered or asked. And one is about mistake number one with, running and operating a business. One person asked, I am LLC, but single owner. Is that okay?
That's fine. An LLC single owner, LLC is looked at the same as basically any other corporation in regards to legal liabilities. It's only liable for the assets owned by the LLC. Where you need to be careful is that you do not put any other assets into the LLC, such as your car, perhaps any other equipment that may be used. If some people who run more specialized travel, we form separate LLCs. The LLC will hold the equipment. The other LLC, which is the operating entity doing reservations, etc., will simply have no assets outside of their personal computer or what have you. And therefore, if a lawsuit happens and they get through to the LLC and there's a liability factor, there's not going to be much there. And a lot of attorneys for the plaintiffs will, first of all, look up at the LLC and say, hey, even if we win this, what are we going to be able to go after? So certainly it's very, very advisable to use an LLC or a sub-S corporation in this regard. and very helpful, and I recommend it. Some host agencies make it mandatory now that you have to act in the capacity as an LLC or sub-S corporation.
Great. And another question here, and you might have kind of covered this one, but I know that we have a lot of independent contractors and on this call as well. So I thought this would be really helpful is one person asked, what would be recommended if I do business as XYZ company through a travel agency as an independent contractor?
That's what also very, very much recommended. Of course, you can use whatever name. You could use your personal name. I don't particularly recommend that, but it's helpful, and it's also very advisable that as an independent contractor, you use an LLC or sub-S format as well. Again, that restricts your liabilities. You also want to look at the independent contractor agreement, which is really a subject for a whole nother seminar, but to make sure that it clarify what it says in there. A lot of independent contractor agreements with the LLC or the individual themselves mix up an independent contractor and an employee, and we've had a number of cases where that's a problem. The host agent, especially if it's a smaller host agent, thinks they can demand certain hours that the individual works, so they have to show up on Saturdays, etc. What they can and cannot do. You can't have those in an independent contractor agreement, and the host that is putting those in there can be subject to IRS penalties as well.
Good. Yeah, that's really good. Good information to know. There was one question too that was unique, and this is really perfect because you're in Florida as well. And someone said, I'm a home-based agent and have the LLC registered under my home address as required by the state of Florida, but all mail goes to a USPS post office box. Am I exposing personal assets?
No, you're not. The LLC, as long as, again, as I said, as long as you do not put any of your assets in there, it's not infrequent for somebody to say, well, I've got a company, I'm going to make the company car so I can write it off. Not a good idea. Maybe you want to write the car off anyway, but you know, there are ways to do transportation as a write-off without putting an automobile or anything else possible into that LLC.
Perfect. And now moving on to, and I know that we have other questions too. So just heads up too, since we probably won't be able to get through all the questions too, feel free to reach out to me and we can get you contact information and I can follow up with Laurence too as well on that. But I want to move to mistake number 2. There was one question that just came in and it was a really good one, is in securing client information and data, do you recommend that travel businesses use only a secure cloud location like Dropbox to keep client data?
That's very recommended. Keeping your data in the cloud. One of the biggest problems, as I said, you may put them on a disk, and the access to that information, especially if you're running from your household, you don't want anyone else in the household to be able to get on the computer and access that information. Not because they may intentionally do it, but because you may have a hacker involved and the information then becomes exposed and you become liable for that. So again, putting it in the cloud is very, very important, if not some secure method. Do not just leave the computer on for any of the kids or spouses to go look at in regard to that information. It needs to be protected. And if you're taking it with you on your cell phone or whatever, again, you need to make sure that that information is protected. We have situations where, actually, we talked about in another seminar, you have individuals who will proceed through let's say a casino or hotel lobby. They have what's called a pineapple. And what that is it pretends to be the hotel's Wi-Fi. And so you connect to the hotel Wi-Fi, and now all of your information becomes exposed. This individual, actually, one of our clients, so to speak, who deals in that type of activity, he knew what was happening. He approached the individual afterward, and he said, I'm not police, but he said, tell me what you do with that. And he said, I don't really have anything to do except take the pineapple, deliver it on a weekly basis, and receive $10,000. I don't know the people I deliver it to. So it's very easy to access this if your information is not well protected. And again, the hackers are out there. They've done just everything. They get online as well. They pretend to be even large law firms. We've had situations where they've taken the client for $200,000 and $300,000 in losses, thinking they were actually dealing with a real law firm because they used their something mimicking their website.
Wow, that is crazy something like that exists. It's good to always be aware of what's going on. Another question too, kind of dealing with security and privacy is, and you kind of you're talking about how there's many horror stories for this. So I think this is one is cruise technology such as Princess Medallion technology. Agency could be held, could the agency be held liable if cruise lines technology is hacked?
Yes, actually, it could. It's a developing field. I had a talk on board the ship. There was a reception for some attorneys and others about 2 years ago when this technology was just coming out, and I spoke with one of their counsel, and I said, "How are you protecting this information now that it's able to be gathered so easily?" And basically, he said, "Well, let me tell you what happened. Marketing got ahead of legal." And he said, "We're having to catch up with this." So yes, the information, should be addressed to the client, that you've got to keep your information, protected, because you know what information may go on those medallions, and you could be held liable, especially in the result of a situation like a divorce or something, where the client shouldn't be with the person they're supposed to be with.
Yeah, and yeah, it's something again, yeah, be very aware of that. The other thing too is let's see, we'll do a couple questions here, and I know we got started a little bit later as well here, but to kind of go into mistake number three, how this was kind of a good one, is how do you suggest that we explain these forms to clients? Won't this make them skittish about booking with us? So have you ever had to deal with that where you're like, I need you to fill these forms out and explain why, or did you have them question?
Well, yes, in general, the terms and conditions agreement that I have on there, we usually will attach that, as I said, to the website. It can be on a back page, but it has to be noticed at the beginning of the website in something like, the use of this website is conditioned upon your acceptance of the terms and conditions on page wherever you start. The cruise lines do this, the airlines do this. It doesn't have to be right in front of them, as long as there is a format. It's better if they have to click and agree to the terms and conditions. That's the best recommendation. But the courts have held, as long as it's provided on there somewhere. Now, of course, you like to have the client sign it, but you don't want to chase the client away either in person to have all these terms and conditions. Where it's most important is on an adventure tour type of travel, that these terms and conditions be signed by the client themselves, because there are a lot of liabilities there, and you need to know and have a little experience with what you're selling and the companies you're selling. For instance, one of my clients is a travel agency tour company that deals with hiking in the Andes. The local supplier of these tours cannot obtain any type of insurance down there. So you want to know how well they're covered, and that they're covered, and that you're not going to be sued because somebody on your group sues them for an act they committed. So there are interesting forms like that. I represented a company which dealt with chartering French river cruises on the small side, the little boats, and they were presented with a one-page agreement. Well, that's completely insufficient to cover them. So, we had to do a 3 or 4 page agreement, and it had to be covered under European Union law as well. So you've got to watch your suppliers, and you've got to watch who suppliers they may use, and make sure that they cannot come back after you for any liability.
Great, that's really good. And one more question here is for Canadian law here, and I know, and you touched on this, but in the Canadian law, when it says when you mentioned not meeting the client at home, did that refer to the independent contractor's home or the client's home?
No, it basically referred to the client's phone.
Got it.
They have to be extremely careful. They can't actually visit a client at home. which seems rather strange here because a
Yeah.
number, especially if you're an independent contractor, you may go visit the client at home. That's not permitted in Canada.
Yeah. Yeah, that's so crazy. The things you learn, the pineapple, the Canadian laws. Yeah, it's all really good. And actually, that was a quick question, so I'll do one more here. So this one question is, I have clients pay me a research fee and I get commissions. However, I do not use my corporate credit card to pay for any of my clients' reservations. I provide theirs. Is this okay? And does it have any inherent risks you have not already discussed?
Uh, if you're using their card, as long as you have such a release like we're talking about, especially contained in that use of personal information, which is pretty new, that basically excludes you from any liabilities. And them, because they're supplying their credit card, you're informing them that you're going to supply the information to a third party, and it's necessary as part of the travel to do this. And therefore, you cannot be held liable for what the third party may do with that information. But it's very important to have one of these release of personal information type of documents now in the business. It's very much, especially if you're hacked, for instance. You've got all this personal information on there. So you don't want to be held liable to the most extent you possibly can and really protect your information, especially in use of their credit cards. You want to tell them how long you are retaining their credit card. You try not to use their credit card in any online document which could be hacked. So you've got to be careful there.
Yeah, that's really great to know. And thank you so much again. I know this was a lot of great information. We had a lot of great comments. People found this very helpful. Just to mention a couple things before we go here is that you will get the recording after this. I know some people mentioned wanting slide information, and then also we had a couple people ask about transcripts. So just follow up. I can provide transcripts after this once the video renders and goes through. But other than that, I just want to say thanks again, everyone. And thank you so much, Laurence. Thank you so much for taking your time to let us know about all this information. It's very important information to know.
Well, you're welcome. That was just an overview, as I
Yeah.
said. We have a number of programs which deal more uh, intently with a lot of these documents and concepts.
Yeah. Each one of these slides could have been a whole hour webinar. There's so much information involved. But again, everyone, if you want to check out Laurence's website, email him. You can also email us for that contact information. But have a great day, everyone, and enjoy the rest of your day and have a great rest of your weekend. Thank you so much again, Laurence.
Thank you. Appreciate it.
Thanks. Bye.